Do you rely, to what extent do you rely on the fact that your clients include an existing student loan borrower, and that you have it a little different than one that is not? In other words, it's not speculative in the question of how would that person be remedied, but it is another borrower. You're asking for notice and comment, and during that period, if it's granted, that would it would entitle you to raise, why the limit, whatever the credit limit is, that should be changed. Is that, I mean, I think your challenge is to make that sufficiently particularized and non-speculative. I mean, the problem with standing jurisprudence for something that looks for something concrete and particularized, it's also very academic. A dollar of injury and you're in. Hundreds of millions that they can't trace directly to the agency action, and you're not. So what is it that makes the interest of your client who has a $17,000 loan, how is that sufficiently concrete and particularized in the context of something that the government would address if it can't do what it's doing now?
Sure. So I think it is critical that we're here representing borrowers. She has student loan debt, and it's not being repaid, and those are concrete interests at stake. So this is not someone off the street who is upset that his or her taxes are going to go up. There's no question that'd be a generalized grievance. But here, if you look at the scope and the purpose of the program, it's to help student loan borrowers. But instead of doing this through negotiated rulemaking and notice and comment, they carved up the lines and they did it all in secret. I'd point the court to page 31 of the government's reply brief. On that page, the government said that it had extensive discussions with banks and ultimately decided not to forgive FFEL loans. That's the type of thing that should be happening on the public.